Commonwealth versus Spearin.
Mr. Campbell, you have 5 minutes.
Good morning, Your Honor. My name is Alan Campbell. It's my privilege to represent the defendant, Gulthair Kamara. I had intended on focusing on my challenges to the 2 assault convictions. However, counsel for the Commonwealth has just informed me that they are going to concede that the evidence was insufficient as a matter of law to support the convictions and that those convictions should be vacated. So unless there are any questions on that, I'll turn to the other.
Well, I'm going to wait to hear from the Commonwealth, but I see the Commonwealth is nodding, so I'm going to assume that the Commonwealth will make that.
What's the name of that defendant?
Gulthair Kamara.
Okay.
There are 2 other issues that I will try in 5 minutes to get through. The relevance one I can touch very quickly. There was a fight between some 10 weeks before this incident. There was a fight between.
According to this card I got you down for 10 minutes. Has something changed?
Actually, I thought I had 10 minutes too.
Okay. Okay, I'm sorry. Mine
I do
says
have
5.
the
But
10 minutes?
you go right ahead.
Okay. In that case, I'll actually take the hostage charge next.
Okay.
And the court did not adequately define the offense of hostage taking. The defendant did not object to the instruction, so we're under the substantial risk of a miscarriage of justice standard. But where the elements are misstated or omitted, that's a clear case for substantial risk, because the jury will not have been required to find all of the necessary facts to support the conviction.
Well, surely someone was taken hostage here, and surely the defendant was charged as a joint venturer in that hostage taking.
Somebody was taken hostage by Richard McMullen. However, as in the instructions did not lay out the elements that somebody had to be seized or detained, that there had to be a threat to kill or injure or continue to detain.
Well, your argument is that the instruction should have said seized and detained, rather than seized or detained.
Element 1 would be seized or detained. Element 2 is to threaten to kill, injure, or continue to detain. As instructed, it was to seize, detain, or threaten. So the first 2 elements were merged together. And the reason this is important is because there was no question McMullen took Officer Florent hostage. No question. He has him as a hostage. The primary question is whether the defendant joined in a joint venture.
There's no debate that the officer was threatened either, is there? Someone held a 12-inch piece of metal.
McMullen held.
So the officer was threatened, wasn't he?
Well, there's no. I don't know if there actually was a threat made by McMullen. The threat here, testified to by 2 of the officers, a third officer attributes the threat to McMullen, is that the defendant is at a window with a screwdriver or something and says to officers that are approaching the window of the HB unit, if you come in here, and I'm cleaning it up some, we'll kill him and then we'll kill you. The officers stop. As instructed.
Well, wasn't there also testimony that Mr. Kamara had a screwdriver in his hand?
Yes, that's what I just said. He had some metal screwdriver or a lightning rod or something to that effect at the window saying that. Florent is not at the window at that point. Florent is with McMullen someplace else. And that threat was never, Florent was never learned of that threat. That goes to the assaults. The reason that the instructions were unclear.
And if you guys try and come in here, we'll kill Florent and then we'll kill you.
Correct. That threat was certainly made. And it was heard by at least 2 of the officers outside who had been approaching. They stopped their approach.
And then within a moment or 2, then Florent was brought out in a chokehold with a screwdriver up under his chin.
Correct, not by the defendant. At this point, there are approximately 100 inmates in the HB unit. It's not clear how big it is, but there's approximately 100 inmates in there breaking the place up. There's no question the defendant was close by. The defendant certainly shouldn't have made that statement. But as instructed, the juror would have had to consider 2 things. They could look to the joint venture as to whether the defendant joined in with McMullen, Or they could simply apply the very unclear instructions and say the officers that were coming up stopped because of the threat that was made. All of the elements are for the hostage taking as given were satisfied by that simple, largely uncontested incident that has nothing to do with Officer Florent. Because jurors could have found that as they approached and stopped, they were detained by the threat. And that the threat was designed to make them stop coming into the building. They stopped. They did not come into the building because of the threat. That would be much simpler for the jurors to have convicted based on that than to reach the much harder question of this mob mentality, all these things going on. Did the defendant agree? Did he not agree? That's why it was problematic, because the indictment only applied to Florent. It was that specific incident. The judge, and remember, this was a very complicated case, not factually, but for the jurors, because you had 5 co-defendants tried in combinations of 6 different crimes. And for the most serious, there's a 2-paragraph instruction.
Mr. Campbell, let me ask you to address the Commonwealth's claim with respect to that, which is they say, the word hostage is coming out, but most laypersons would have, quote, a pretty good idea of what it meant.
They may have a pretty good enough idea, but they were also given instructions. Seized, detained. People also have an idea of what it means to be detained. If you're walking and an officer says stop, and you stop, many people would think that you have been detained. Thus, as instructed, simply don't come in or we'll kill him. Those officers were detained. The court could have given, very simply, the court could have said, these are the 4 elements, as he did with all of the other instructions. These are the 4 elements that the Commonwealth has to prove, A, B, C, D. Let me tell you a little bit about each one of them, and then give a couple of paragraphs to say what the various terms mean. Remember, the jurors have heard 6 closing arguments, all of the charge, and then they have to go back. I don't know how long it took to read the hostage charge, but you're probably talking about 15 or 20 seconds.
Well, is
serious charge.
Is your objection to the charge beyond simply the use of the word or rather than and?
Yes, there are 2 other, although, quite frankly, it seems like a small matter of semantics, but the or and differentiates between whether you have 1 element or 2 elements. And there are 2 elements. So
no, I can certainly see in another case it might have more of an impact. It's hard to see how there's a substantial risk of a miscarriage of justice here based on the facts in which this perhaps mistaken.
Well, again, the reason I think that it does give rise to the substantial risk of miscarriage of justice is because of the other officers testified that they heard the threat and that they stopped their advance into the unit, and that the instructions did not specifically limit the charge to Florent as they should have, because the indictment was specific to Florent.
When the prosecutor was arguing the case to the jury, was the prosecutor suggesting that he or she had satisfied the requirement of a threat?
The prosecutor, specifically relating to the incident outside that I'm talking about, the prosecutor didn't argue that outside incident could have satisfied it. But the arguments were all very quick. He had, in approximately 15, 20 pages, he responded to 5 closing arguments. He merely focused on, he largely focused on what McMullen had done.
But did he acknowledge that there were 2 aspects to the proof in the hostage indictment?
I actually don't believe that the prosecutor went through the elements
I take it
in his argument.
Mr. Campbell, let me see if I can, I understand you've gone through point in your brief, but as I understand it, you're saying, look, there was evidence that McMullen, from your client's point of view, may have taken Florent hostage, right?
Correct.
There is insufficient evidence that my client, Kamara, either joined in the venture to take Florent hostage, and there's insufficient evidence, not insufficient, but in light of the instructions, what my client has been convicted of is taking 2 other officers hostage, and the jury instructions as to those are erroneous because they could have been merely detained. There was no evidence that there was any threat. Do I have it?
Largely correct, although there was probably sufficient evidence to send it to the jury that the defendant joined in a joint venture.
Of the hostage taken of Florent.
Of Florent. But given the sort of the mob mentality, the lack of any evidence that the defendant ever communicated to Florent or to McMullen, just the various testimony of the way...
Wasn't he standing very close to, wasn't Mr. Camara standing very close to...
At various times he was close, but again, there's 100 people, 100 inmates acting like inmates who are upset. It's a riot. So they're in a space, we don't really know how big the room is. At one point there was testimony that something was 10 feet from something, but we don't know whether there were 100 people in a room this size, half this size, twice this size. So simply the fact that he was near him really doesn't get us very far because there are so many people there.
Well, near, within an arm's length of him.
At times, sometimes he was close, sometimes he was not close.
While he had this screwdriver or whatever it was against the neck of
I don't believe there was testimony that he was arm's length while McMullen was holding him with a screwdriver.
But I think you need to concede, as I think you just actually did, is that there was sufficient evidence to convict your client of a joint venture hostage taking. The question is, your issue is, he also could have been convicted of something else.
Exactly. And so that's something he was not charged with and may not actually...
Which is making threats unrelated to the hostage.
Correct. And that if the jurors convicted him of hostage taking on that basis, then the conviction must be vacated because he was only indicted for specifically taking Officer Florent as a hostage.
Thank you, Mr. Campbell.
The red light is up, so I will rest on my brief for the relevance of the other issues.
Mr. Mazza?
Good morning, Your Honor. May it please the Court. Joseph Mazza for Defendant Randall C. Spearin, who would emphasize his first argument before resting on his principal and reply briefs. The defense maintains that the conviction for damage to a building while unlawfully assembled in a city or town under Chapter 269, Section 7, misapplied the municipal riot statutes. And what we're saying is that, in short, a county jail facility is outside the confines and controls of a municipality, and we're asking that that element be strictly construed.
May I ask you then, assuming hypothetically that there was a disturbance in a county jail, what charge should be pursued against the inmate?
Okay, common law riot is available. Now, that would pertain really to the unlawful assembly. And from Commonwealth v. Frischman, the statutory scheme is entirely separate, distinctly different from common law riot. As to damage, there are several choices within Chapter 266 for every type of facility, for various types of buildings,
But this wasn't one of them. This was the wrong one, you say?
Yes. Well, actually, he was charged under 266, I think 130, and that was a foul conviction. It's not before the court. But there are other choices in there as to damage. As to common law riot, that's still available. But the real problem is what becomes of the liability for property damage. Does the town of Dartmouth have to reimburse the county or the state for damage to the House of Correction? And what we are suggesting from the amendment history is that in an act relative to the police powers of the University of Massachusetts at Amherst, which allows the UMass police to make mutual aid compacts and so on, also specifies that UMass Amherst is a town for purposes of 269 Section 1. It does not add UMass Dartmouth. It does not comment on other houses of correction or county jails, any state facilities. It's just UMass Amherst. And an interesting question becomes, if there's a riot at UMass Dartmouth and a riot at UMass Amherst, who's liable for the damage?
Mr. Mazza, is it your position that there are separate laws for riots in municipal facilities, and then a different one for county facilities, and is there a different one for state facilities? Is that your position?
No, Your Honor, not quite. What we're saying is that there is a municipal element in the municipal riot statutes, Chapter 269, Sections 1 through 8. And what we're contending is that that municipal element is not met in a state or a county facility.
Well, under the statute, if there's a riot in a local house of correction, a county house of correction, can the selectmen of the town where the institution lies, can they knock on the sheriff's door and say, okay, we're in charge here?
If the municipal riot statutes are applied, yes. And that's consistent with the history of the statutes, which actually the statutes originate even better. The colonial legislature had the Riot Act of 1815 available to it. Reading the Riot Act was the order to disperse. What they needed was the Posse Comitatus statute because the Boston militia had failed to respond to Governor Shirley's call out to the militia to quell a riot of 300 Bostonians protesting the impressment of 48 Bostonians into the British Navy. So when they set out the Posse Comitatus of nature, that was no accident. That was quite deliberate. And in a city or a town, the municipal officials do have authority. So if the roundabout answer is that if the statute pertains to a county jail facility, yes, they do have authority to knock on the door, and which is not consistent with the statutes and regulations authorizing the Department of Corrections to maintain the facilities, control the facilities, and so on. It's not consistent with the doctrine of essential government functions, and so on.
Mr. Mosley, your time is up.
Yes, thank you, Your Honor.
Thank you, Mr. Counsel.
Thank you.
Mr. Mark?
Excuse me. May it please the Court, David Mark for the Commonwealth.
Excuse me, Mr. Mark, how do you respond to the argument that's been made about the recent amendment to Chapter 269, Section 1?
It's a very interesting amendment, and here's how I would respond to that. You may or may not realize that unlike, for example, the Harvard Police, which is a security service, except insofar as certain members are appointed special state police officers, the police department of the University of Massachusetts at Amherst is a real police department. But they suffer from this peculiar infirmity. This is a place where from time to time there are actual riots for one reason or another. And the problem they faced was that while they were a police department, they were not a police department of a town or a city as described in 269 Section 1. So arguably they would not be able to deliver the, as it were, conditioned precedent for arrest and prosecution under the statute. If you're not one of the designated officials, you can't say you must now disperse or else. Subsequent to the amendment, they now can do that. They're now effectively a city or town for purposes of delivering that message. That is our reading of the statute, and that is not inconsistent with our reading of the remainder of this, our view that this is applicable. May I just sort of segue to Justice Spina's question that he addressed to my brother, Mr. Maza, about what happens if the selectmen knock on the door of the House of Correction while the riot's going on and say, "Excuse me, I'm in charge." I acknowledge that as a possible peculiarity of the statute, but the point I would make is that it's not in any way limited to this kind of situation. What if there were a riot downtown and the police were handling it and the selectmen came along and said, "Excuse me, I think we're in charge"? There's no real difference there. The problem, if it is a problem, exists whenever the statute is applied, even in those instances where it absolutely clearly does apply. There's nothing uniquely about a House of Correction that makes that any stranger than it would otherwise be. The problem arises, I think, because of the antiquity of the statute. As I said in my brief, it goes back a long way. The original version of the statute is from colonial times. It's 1750 is the date of it. And there are a lot of retained provisions that no longer make a great deal of sense in a modern context.
Should the word assembly that appear in the statute be understood in the context of that word as it appears in the state constitution? Should people have a right to assemble under the state constitution in public places? The House of Correction is not a public place. Should we construe the statute, or shouldn't we construe the statute in a way that's consistent with the word assembly and unlawful assembly as they appear in Article 19 of the Declaration of Rights?
Well, I guess the answer is no, Your Honor. The statute predates the Massachusetts Constitution. I think
using the term assembly.
That, without looking, I can't be sure, Your Honor. But so much of the language has been retained. I think that the argument we would make is that the manifest purpose was to address the suppression of riots, to ameliorate the harm of such riots, and the language is plain and clear. I don't think there's anything anywhere in the legislative history that allows you to draw the conclusion that assembly, as it's understood in the Constitution, is being referenced in these statutes.
I take it that it's, at least the Commonwealth's position is that it's a more straightforward definition, which is wherever people assemble,
yes,
get together, and indeed
anywhere in a city or town. It doesn't, regardless. I mean, if it were in a
private
property, it would still constitute a riot. It would still be amenable to suppression by the police under the statute.
But why isn't it trespassing?
It may be as well, but
this
no reason
happened not to be trespassing. In other words, you could have a riot in a private property to which people either had or hadn't been invited. Is your point correct?
Yes, Your Honor.
So that so the 269 Section 7 will apply even if you simply have to be within the geographic boundary.
Yes, Your Honor. That would be. We're arguing for a straightforward facial reading of the statute. It applies on its face. If you look at the statutory purpose, that would support the idea that it applies, and using only those sort of first-order tools of statutory interpretation, we arrive at the right result here.
But then the selectmen incur a liability if they don't knock on the sheriff's door during a riot.
Again, Your Honor, the problem is that that sort of peculiar problem arises in all of these contexts, where it would be perfectly obvious that the selectmen ought to stand clear and that they're not, equipped to handle a situation that may have arisen. So, yes, that might be a problem under the statute, but it would be a problem for any application of the statute, arguably, not just one where the riot happened to occur in a House of Correction. Remember here, the part of the safety valve, as it were, is that in order for the statute to be triggered, the person delivering the warning has to be one of the designated officials. Well, here, of course, it was, because the House of Correction is run by the sheriff, and the corrections officers are deputy sheriffs here. Something that was covered specifically in the evidence in order to make sure that the elements of the crime were met.
Should we get your concession on the record?
Yes, absolutely, Your Honor. In the sober light of argument preparation, I felt that. Let me take a step back. The evidence for the two assault crimes with respect to Mr. Kamara was the very same evidence of the hostage taking. It's essentially a course of conduct that violated several separate statutes. It is clear to me in reading the transcript that the judge intended to, or at least the prosecution intended that the judge charge on joint venture with respect to the two assault, or at that time assault and battery crimes, as well as the hostage taking, and he neglected to do it. At somewhere in the very short volume 7, you see a sort of light bulb go on over the judge's head as he realizes he hasn't done this. At least that's my reading of this. But the point is he hasn't. I made an argument in the brief that I feel I must abandon. There's no real case law support for the kind of hybrid vehicle to surmount the problem that we had here, which is that on either kind of assault, threatened battery or attempted battery, there was no direct evidence that of either that Officer Florent perceived or heard the threat, or that there was any attempt to hit him by this defendant, Camara. Under the circumstances, I just, when I looked at it again, preparing for argument, I just wasn't comfortable that there was a viable means of working around the problem created inadvertently by the failure to charge on joint venture here. I informed my brother in order not to have him expend his precious 10 minutes arguing something that I think he's correct.
So the two charges that are out are assault on a correction officer and assault by means of a dangerous weapon?
Yes, Your Honor.
Mr. Mark, you've been very clear, but it would be very helpful if you could send us a post-argument letter just confirming that.
I will do that, Your Honor. Let me turn to, if I may, Mr. Camara's argument about the hostage-taking charge.
Just one more in the letter. You're going to say verdict for the defendant on those? What are you going to say?
I haven't thought it through, but I shall say that. That seems appropriate.
That's what you got to say.
Yes.
You're not going to attempt to null cross or anything.
No.
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 Okay.
Okay. I will. If I may.
Yeah.
Addressing the adequacy of the instructions on hostage taking, which is Chapter 127, Section 38A. Our argument is actually that as Justice Cordy said, that indeed the judge did make a kind of slip of the tongue mistake. He said, or where he meant and. I would argue several things. One, repeatedly in the short instruction the judge referred to hostage taking, and I do believe that is not a legal term of art in the sense that, say, malice would be, where you have to get the technical definition correct to understand the difference between the common definition. Here the legal definition and common definition are the same for hostage taking, and he repeatedly referred to hostage taking. Beyond that, an attentive juror would have understood that this had to be a mistake, because otherwise you end up with the absurdity that you could continue to detain someone who hasn't yet been detained. It only makes sense, this language from the federal hostage-taking statute only makes sense if you read that you require that there be a seizure or a detention, and then one of these other conditions, that there be a threat, or there be injury, or there be continued detention. But continued detention without a first detention doesn't make any sense. So the very language that was read would alert the jury to the error that was made in reading that. It is an isolated misstatement, and I think it's one that's readily...
But would a seizure encompass detention?
The words are used here interchangeably in the statute, seizure or detention. So I guess the answer would be yes, that one or the other would suffice.
How was the case argued to the jury? Was it apparent from even the way the lawyers were arguing the case that this was a slip of the tongue by the judge?
You mean there's a very long and I think very good discussion of this on the part of the special prosecutor who tried this case on the evidence that proved that Mr. Camara had engaged in this crime as a joint venture. Whether that would have alerted them specifically to the slip of the tongue mistake, I don't know. That would require a great deal of comprehension on the part of the jury to relate. I think it's, considering that we are permitted to, indeed required to assume that the jurors understand these instructions, I think I'm entitled to argue that attention to that language would reveal the mistake. But I don't know that I can say that attention to the argument of the prosecutor would reinforce that. I suppose it might.
It might if you were looking at a substantial risk and saying what the jury was really focused on was the joint venture.
Well, that's the point I was about to get to. So yes, Your Honor, that's certainly the case, because really the argument is about joint venture, as I think you noted, Your Honor.
there was no question, indeed, I think my brothers conceded, there's no question that McMullen took Officer Florent hostage. The question was that whether the extent to which the evidence revealed a joint venture with McMullen on the part of Camara. I would add that the evidence there is substantial. This is a case where you have the parties acting together at the climactic moment, I believe is the language that this court has used, rather than necessarily any sort of pre-existing arrangement. But it's clear that they came together with a common purpose, and that is obviously seen by this moment, which Justice Ireland referred to, where Camara is parading up and down before the window, holding his, I think it's a screwdriver, and saying, you know, if you come in here, we're going to kill Florent, and then we're going to kill you. There could be no clearer demonstration of his, of his mental state, of his combination with the prime actor here to accomplish the end. I would rely on my brief for the remaining points unless there are questions. I will submit the letter that you have requested tomorrow.
Thank you, Mr. Mark.